It looks lovely out. I don't know, what is the temperature?
Indeed.
46. It is lovely out.
Yeah, it is. Well, welcome everybody. Good morning, good afternoon, good evening, wherever you are in the world. If you're listening to this live, and if it's a recording, thanks for making a little time to listen to us. My name is Dave Cohen. I'm a director here at Level Up Consulting Partners, and I'm here with my colleague Wills Catling, also a director here at Level Up. Wills and I are also speaking to you today for listening from the great states of Maine and just over the border in New Hampshire and northern New England here. We were just commenting on how it's springtime. Hopefully, wherever you are, things are opening up and warming up if you're in the northern climes. So again, thanks for joining us today. And what we wanted to do today was just to cover at a very high level some very important developments in the personal information collection and processing world, the privacy and IT security world that occurred just earlier this month here in April 2024, as we're speaking to you, which was the introduction of a bill, the APRA, the American Privacy Rights Act, from a bipartisan introduction that would, if passed, create a federal privacy law. We'll get to the predictions as to whether that will pass in just a few minutes. Wills and I have both been in this the privacy space for many, many years now, and we've kind of been through this before. So we'll talk a little bit about that. But before we do, just a kind of a top level overview of this. First off, it's a bipartisan proposal, as I mentioned a moment ago, earlier this month in April 2024. And it was introduced by Senator Maria Cantwell, who's a Democrat from Washington, and Representative Kathy McMorris Rogers, who is a Republican, also from the state of Washington. As an interesting side note, I was listening to a webinar recently by Julie Brill, who many of you may know is the current Chief Privacy Officer at Microsoft and the former commissioner at the Federal Trade Commission. So a lot going on in the privacy space over there in the state of Washington these days, with some very influential women behind some of these efforts. This is a draft discussion bill. So very important to point out that this still has a long way to go in terms of wending its way through Congress before it becomes law. So early days here. However, it's a pretty significant piece of proposed legislation. A couple of key things which we'll touch on during our time together here is that if passed in its current form, again, things can change, the bill would, if it became a law, would be a preemption of current U.S. state privacy laws. So all of the state privacy laws that we've been tracking and trying to keep you informed about, and that companies have been working to comply with, would be preempted by the components of this law if passed. Similar to a lot of the state privacy laws, data subject rights exist. Ones that you all are probably pretty familiar with at this point: the right to know what personal data is being collected, the right to access that data, to correct, to delete, to receive that data in a portable format, the portability, the right to opt, and importantly, the right to opt out of targeted advertising and polling. So it provides those rights. The scope is kind of interesting as it's currently written. It's covered entities include any entity that collects, processes, retains, or transfers personal data, or it has it done for them, and who's subject to the FTC Act. However, there are some exemptions. Companies with $40 million or less in annual revenue that collect, process, retain, or transfer that covered data of 200,000 or fewer individuals, and that do not earn revenue from transferring covered data to third parties. So importantly, smaller organizations are exempt, as are entities that are currently in compliance with either HIPAA or the Gramm-Leach-Bliley Act. So some interesting carve-outs there in its current incarnation. So that's kind of and then lastly, and we'll talk a little bit about this, the bill as currently written provides for a private right of action. So class action lawsuits, individuals can sue companies for alleged privacy harms. So again, top level in draft. Wills, we've been here before. What are kind of some of your top level thoughts about this very kind of surprising emergence of another federal privacy bill.
Yeah, thanks, Dave. I think it's interesting timing for sure. I mean, I don't think anybody would have thought during an election year that we would get another attempt at a federal privacy bill or law making its way through. I mean, clearly, from all the experts that you listen to and those that are embedded in data privacy, it's clear that the US needs a federal privacy law,
Right.
and it needs it sooner rather than later.
Hmm.
Um, I probably listened to the same podcast as you did with Julie Brill on it, where they talked about, if the US wants to be at the table discussing data privacy as a global issue and wants to be seen as a global leader, it's imperative we have a federal bill. And also from an operational perspective, we're just seeing this continual proliferation of state bills, which we knew would happen. If the Fed doesn't act, the states are going to fill the gap that's left behind. So it's just like you feel like you're at an auction block, and every time you turn on your computer, there's another bill passed. So uh, you know, is the APRA perfect? No, it's certainly not perfect, and we can certainly talk about some of the issues with the way it's been drafted. But as you said, it's just an early draft, initial draft. Um, the shooting it down and not moving forward in any way, shape, or form it is not, in my humble opinion, not the right way to go here. It's like, we continue to hear all of the reasons why we can't have a federal bill, and it's like we can't get bipartisan support, and the two sides of the House have never been further apart in how they view things. One sees things more from a consumer perspective. One sees things more from a business perspective. We can't stifle innovation, but then the other side says you're taking advantage of the individual, the consumer, and the use of their data. We look at Europe, and the GDPR started its discussions in 2011. So you're talking 13 years ago. And they really are. I mean, it wasn't just bipartisan. You had 28 different, at the time, 28 different member states that had to be pulled together. So you weren't only dealing with different sides of the house, you were dealing with different countries, with different cultural aspects, with different, stakeholders that they had to answer to in their own countries. And then within that, Europe has a much more diverse uh, parliamentary system than we have here, where, let's be honest, it's predominantly, or is, two parties, it's Democrat, Republican. But I believe at the time that the GDPR went through, I think there was up to 8 or 9 different political parties sitting in the European Parliament. So it's, this bipartisan, we have to get over that. And I don't know how. Those smarter than I have not found a solution to it. So I don't know. I mean, I think it's a good first step. I think it has a lot of interesting terms. I'm interested that they had to, create new terms that we haven't seen before. Things like large data holders and covered high impact social media companies, and now it's no longer, is it personal information, or is it PII, or is it personal data? We've now got covered data, and so again, it does create more operational aspects for organizations to be aware of. But as much as I know you talked about the preemption, and obviously California's already pushed back on that aspect of the APRA. It's Yes, we've got currently 5 states in effect. We've got another 12, I believe it is, coming down the pipeline. So we're going to have 17 state laws in the next couple of years. But there's still, as we stand today, there's still 45 states that really have no privacy law. So there's no consumer protections from privacy other than at a federal level or sectoral level. So passing a federal bill would bring those, at least all those other states and all the consumers who reside in them, up to a level playing field. But I'm imagining there's a lot of conversations to happen here, and hopefully those conversations continue to move forward.
Yeah, absolutely, Wells. I totally agree with that. And I think it's fascinating to look at the political dynamics involved, and we'll talk about our predictions for passage a little bit later in the discussion here. But just so folks kind of understand, some of the tensions involved here are that you can hear industry clamoring for a federal privacy bill so that business has a simpler and more uniform framework with which to comply. Our clients have a pretty complicated decision-making process to make with regards to making sure that their compliance efforts take care of all the individual state privacy laws at the moment. So industry would love some harmonization and some simplification. At the same time, you get this issue of preemption, whereby if this bill passed in its current form and preemption remains, it would set this federal ceiling, not a floor, as some like to say. In other words, states would not be allowed to pass more stringent requirements under that. I'm not sure exactly how that would work. But you do see, I was reading some opinion on some privacy rights advocacy organizations. The Electronic Frontier Foundation, the EFF, was saying that one of the things they object to is the preemption, in that they think that a federal bill should be a floor and not a ceiling, i.e., set a foundation upon which states could pass more stringent laws. Now, that's from a political construction standpoint, that seems like that might be a good way to go. However, it defeats the purpose of the unified and harmonization of all the laws, right? So it'll be interesting to see how that kind of plays out. Yeah, any thoughts on that, Wills? And also just in terms of preemption, and for the work we do with our clients and for what you've seen, how might that change the landscape? If we suddenly went to this unified, harmonized, single federal privacy law as opposed to this collection of state, patchwork of privacy laws.
Yeah, I mean, and the preemption, although pretty much it preempts everything, it's not a complete preemption of all state laws. So where the APRA doesn't cover the subject, you can continue to. So, for example, Washington's My Health, My Data Act would survive.
Mm-hmm.
Also, employee data or employee covered data, to be accurate, is not covered by the federal bill. So that in California would continue to fall under the CCPA. But yeah, I'm with you. If you don't preempt all the laws and you allow each federal or each state, to use it as a floor and build up from there, you ultimately end up, I mean, to a certain extent, you will have some conformity amongst certain states, and maybe it does mean that certain states wouldn't pursue their own state-based privacy regulation. But you do run the risk of ending up exactly where we are now, which means every state is slightly different. And as an organization who's trying to comply with all of these laws, you're going to then have to learn where all of the increased requirements live, and you're going to have to once again manage to those increased requirements, which is pretty much where we are now. I mean, most companies are looking at the patchwork quilt of US state regs, trying to identify where there's consistency and conformity amongst them, and manage to that, and then look for the exceptions and the higher levels. And you either bring your whole program up to whatever you consider to be the highest standard within each
Right.
control, or we've talked about this before, or you manage each one on an exception basis. So you'd have that same challenge, just with another piece of regulation to comply with. So I think the preemption, obviously, it's something that is a significant stumbling block for California. And as we know, if you don't get California on board, it's going to the federal bill is going to struggle to move forward without California's support.
100%. Yeah, California has had Herculean efforts with their state privacy laws, the CCPA, followed by the CPRA, over handful of years, a lot of effort, a lot of time and energy, and a fair amount of political clout in Congress. So there could be some pretty stiff opposition there. So that gets to what we'll talk about in a minute, and chance of passage. But before we go there, Wills, another rather controversial provision in the current incarnation is the private right of action built in there. So a private right of action would allow for individuals to sue companies if they for alleged privacy harms. Now, you'll hear arguments for and against both sides for this. You'll hear consumer advocates say that this is a reasonable right and puts pressure on companies to tighten up their personal information collection and processing activities if consumers have this right, because there could be some financial damage to companies if they're mishandling data. So you hear that from a consumer rights standpoint. From an industry standpoint, you'll hear both that this puts undue and difficult and very challenging and costly requirements on companies to try to manage the threat of class action lawsuits and private rights of action. And you'll also hear a lot about the potential abuse for this to be just a bit of a cash cow for class action attorneys to be able to bring class action suits that just become a lot of legal expenses on both sides, and doesn't really necessarily provide for increased consumer protection in the long run anyway. So what are your thoughts on this private right of action clause that currently exists in the bill?
I mean, it's limited, isn't it? So I mean, it's limited privacy right of action. So they've defined, I think it's maybe 6 or 7 violations that if an organization committed could lead to a private right of action. Mm-hmm. Again, if you're an organization and you're doing what you should do, foul of a private right of action. But I do hear what you say. I mean, I don't know. It'll be interesting to see how you actually implement that. Mm-hmm. I'm not sure that I know the FTC said it will empower or create a new bureau to carry out the authority under the law. I mean, as far as I'm aware, when you look at the different enforcement agencies, the Attorney General officers across the country are not sitting around looking for work to do. I don't think the FTC is sitting around looking for work to do. So I think finding the bandwidth to be able to handle these private right of actions could be interesting. Mm-hmm. And like everything, case law is going to kind of drive it forward, isn't it? I mean, you're going to see who brings what actions and what actions are successful, and companies are going to. It'd be interesting to see what effect does that cause on a company. Just like everything else, if you see somebody else, I guess you hope that you're not the first one through the door. Yeah. And you can see what happens to another organization.
Nobody wants to be the example.
Yeah, you don't want to be that example. But again, if you're doing the right things with the consumer's covered data, and you're protecting it, and you have the right levels of security, and your policies are clear and transparent, and you're not using data for other purposes than which you disclosed you were going to use it for. You're not discriminating based on protected characteristics, and one of the key ones I think, which we haven't talked about and may not even get to today, is some of the obligations around the let's go AI, let's call it what it is, algorithmic decision making. Exactly. So I mean, as an organization, if the APRA went into effect, I mean, you've got a couple of years until it would go into effect, and I don't think there's guidance wouldn't follow. Probably, I believe they said that guidance has to be provided by the Commission within 2 years of the Act passing, which is interesting because I think the Act is, as it's written, would go into effect 18 months after it was passed. So that will be a challenge for organizations. We saw it in California. You need that guidance as an organization to know what you're going to do, so that you can build a compliant program.
Mm-hmm. Yeah, and to your point, Will, it's really good that you just kind of highlighted basic personal information collection and processing and storage principles, the work we do with our clients every day. Just being aware of what you're collecting, how it's being stored, how it's being protected, who has access to it, and making sure that you're being transparent with your customers and consumers, setting up your data subject access rights, your consumer request processes to make it easy and efficient for consumers to be able to get in touch with you and have access to and control over the data that you're collecting on them. Just the basic, straightforward privacy principles that we work with and help with our clients with every day. So we're getting toward wrap-up time here. So the big question, Wills, that everybody's kind of wondering, is this going to become a law? What are the chances of passage? So what would be your best guess if you're looking into the crystal ball and saying, does this bill have any chance of wending its way through Congress and becoming a law? Thoughts?
Well, strangely, no senators or congressmen have called me for my opinion on this, which will shock everybody, I'm sure.
Yeah.
But chances of passage, I think Monty Python, it's not dead yet. Yes, it is kind of thing, maybe. I mean, I'd love to see it keep moving forward. I think it's critical, as I said at the beginning of the call, that we have it. I think there's, it'll be interesting to see which way it goes. I think for it to move forward and actually become or go into become a law, I think there's going to have to be significant changes to it. And hopefully those that are tasked with moving this forward have those conversations, run open workshops, garner, feedback from consumers and business alike, and as you said, GDPR didn't happen overnight. I mean, GDPR, as you said, the first memorandum was 2011, and then it took another 5 years from that period until it actually became the GDPR, and then another 2 years to implement. So, John Bowman, a good friend who sat in and was the UK's lead negotiator on the GDPR, tells great stories about the discussions and heated discussions around what the GDPR ultimately became. And, I remember him telling me stories of people overnight and sleeping in the meeting rooms and everything else, but they got there. And I feel like it did take a time. And I think rather than this knee-jerk reaction of we need a regulation, we need it now, if we can't get this done in the next 60 days, then we scrap it, is maybe where the problem exists. It's like, maybe this needs to be a longer, where we don't possibly have time for it, but a longer runway for discussions and communications and bring everybody to the table and move something forward. It doesn't have to be perfect, but it should be good. It can be good enough, and the guidance can help shape it as we move forward. But I think as it's written right now, there's too many areas that, it's just going to stop it from moving forward, whether it's, like you said, the preemption, whether it's the private right of action, whether it's the enhanced definitions of sensitive covered data that are going to affect targeted advertising and make it very challenging for online advertising. There's going to be a lot of pushback on that from a business perspective. So, and I think also, this isn't something new. I've heard this said many times. It's, in the US, it's just the culture or the system is set up so that you can do anything with the data unless the law says you can't. Right. And Europe is set up the other way around. You can't do anything unless they say you can. Right. And this regulation, from everything I've read, seems to be stricter than the GDPR in certain aspects, and is almost pivoting some of that positioning from you can do anything with the data to everything is prohibited unless it meets one of the 15 defined processing activities that are in the draft. And without going into great details, it misses one of the key bases for processing, which is legitimate interest. Even though a couple of the processing activities would be considered legitimate interest, but I think I just think that looking at it, they've tried to write it in a way that is going to present challenges in the future, because it's rare that a law can be forward-looking, in sufficient or forward-looking enough to be able to predict what future permissible circumstances will exist for the processing of that data. And I think that's going to present problems that probably are going to be enough just to kill this bill.
Yeah, I would tend to agree, Wills. And I think we didn't even talk about some of the challenges that exist with the restrictions put upon behavioral advertising, targeted advertising, which is so deeply embedded in American corporate culture. So a lot of challenges there, a lot of things that need to be worked out. And as you mentioned, it's a pretty radical pivot from where we are today to where we would end up if this bill passed in any kind of form as it currently stands. So I would tend to agree. I think the chances of passage are low. However, you never know. There is bipartisan support. It's kind of being an optimist. I think it's nice to see both sides of the aisle actually working together, and that there is that kind of bipartisan support. The other positive thing I want to highlight just before we wrap up and close here today is that just the fact that this was announced is getting, we're talking about it. Articles are being written. You're getting major people commenting on it. It's headline news. Raises consumer awareness, raises corporate awareness of the importance of managing personal information well. And so for that alone, I think it's a really positive development and a step in the right direction. And to your point, Wills, it would be nice to see the U.S. Buckle down and be in it for the long haul. And so even if this doesn't pass in the near term, in the current session of Congress, it would be great to see it somehow survive and continue to be worked on, so that we eventually do have a harmonized federal law that companies can comply with, that meets the mark in terms of adequate consumer protection, and something that's doable by companies as well. Tall order, but we can hope, and we'll see. So with that, we're kind of coming to the bottom of the hour here, and I want to give everybody's time back. I know everyone's busy. So thanks all of you out there who listened in today or are listening to the recording. You can see just down below in the window, there's a link to our homepage here at Level Up Consulting Partners. We spend every day working with our clients to help them comply with their data privacy and data security requirements and obligations. I'd be more than happy to talk with anybody out there who's interested in contacting us and hearing a little bit more about what we do here. So with that, I will take us to a program close. Wills, appreciate you taking some time out of your busy day. Great to talk to you as always. And we will see all of you on the next edition of our Insight sessions here. So take care, everybody. Have a great finish to the day.
Thanks, Dave.